This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Joviet. Tonight we're taking your calls and questions about workers' compensation. If you got hurt on the job, how would you pay your bills? How would you pay the medical expenses? And you don't have to have a really dangerous job to get hurt on the job. You don't necessarily even have to be at the job site to be a possible candidate for workers' compensation. But how does it work? There are special rules. And if you don't report it the right way, or you don't go to the right doctors, or you don't tell your employer, you may miss out on those benefits and be shut out. So tonight's your chance to call in, the 31 Law Call number, 256-536-0077. You can also email your questions. You can email a legal question on any legal topic any day of the week. You send it to lawcall@waytv.com, and when we get to a show that's on point, we will pull some of your questions out. And we've got some of your email questions tonight about workers' compensation. William Meservey is here from Timberlake and Lee. Good to have you here.
Glad to be here, Sharon.
We always like to start off the show with a video. We pulled some video off of YouTube, and this one is a little different. Okay, you're going to think about the Darwin Awards when you see this one. We don't know if this is a bartender or a friend pouring this drink that sets the guy on fire. So alcohol burns, you know. Don't try this at home. Don't try this anywhere. But it does appear to be at a business, and he's okay. He's okay, by the way. But if something like this happens, all right, is there a case here? And if it's going on at a bar, William, you guys do personal injury cases. You haven't seen one of these, right? This is a little different.
Yeah, well, we've seen similar.
Really?
But you have to remember, right? So when we're talking about torts, illegal harm for which we're pursuing monetary damages against somebody else, it's like a recipe. So here, we're going to talk about the negligence recipe, right? A duty, a breach, there has to be causation, and then lastly, there has to be damages, right?
Okay.
And he appeared okay.
Okay,
So
thank goodness.
I don't know that we have a full recipe, but
Okay.
I think you'd be able to probably get the other three. However, there are defenses to that recipe of negligence, and one of them is assumption of the risk. So if a person assumes a risk, and then they get injured, you know, it's a pretty good defense to a negligence claim. So here, when you inject alcohol and, you know, he appeared to be doing it voluntarily.
Yeah, he looks like a willing participant.
It looks like, you know, it may be more similar to the Darwin Awards
Yeah.
than it would be a case we could recover for.
Gotcha. We're taking your calls and questions about workers' compensation. So in years past, before we had workers' comp law, if you got hurt on the job, you would have to actually sue your company, right? In order to collect something.
Would. And so, you know, to talk about workers' comp, Sharon, you've got to violate the rules of a first state. And you've got to talk politics a little bit, because workers' compensation is a purely political system. It is formulated, created by, and regulated by the state legislatures. And so, you know, Alabama's workers' compensation system is based off Minnesota's, but it goes back to essentially the Industrial Revolution. You had all these people coming off of farms to work in factories. There was no OSHA. You had people getting hurt, maimed, and killed left and right. For the vast majority of those people, they could not prove it was the employer's fault. There was no security cameras or internet, and they weren't sharing the documents if they had them. And so, you know, essentially, labor and management came together, developed the workers' compensation system. And what that says is it's a compromise. The old common law theory of failure to provide a safe work environment went away. And essentially, if you were injured on the job, as long as you didn't violate certain safety rules or something along those lines, then, you know, you would be compensated for your injury that you sustained on the job. And the compensation would be through the form of medical treatment. And that medical treatment is supposed to be for life as it relates to your particular on-the-job injury. Something called temporary total disability, which is 2/3 your average weekly wage for the time that your authorized treating physician has you pulled out of workers' comp or pulled out of the job. Because in workers' comp, you don't get to select your doctor. You don't get to select the medical treatment you even want sometimes. It's all controlled by the workers' compensation system. And then lastly, they owe you some sum of money for permanent partial impairment or permanent total disability. Now, that all sounds good and great, right? But again, this is controlled by the state legislature.
Okay.
And Alabama's state legislature hasn't updated Alabama's workers' compensation laws since the late 70s. And in the late 70s, $220 was the average household median income for the state of Alabama.
Okay.
That's one of the multipliers still in use today.
All these years later.
When determining the value of someone's workers' compensation claim.
Wow.
$220. It's been adjusted 0 times for cost of inflation, for cost of living, any of those things. So, you know, for some injuries, it's worth the same in 2023 that it was in 1978, even though the dollar's not worth the same.
Nobody's getting rich off workers' comp. No.
Now, Alabama's Supreme Court has said, look, parts of Alabama's workers' compensation system are unconstitutional. But guess what? No one has fixed it.
Oh, great.
So we're stuck within this broken system with antiquated numbers, and you know, trying to explain to hurt workers across the state of Alabama why their claim is worth so little. Now you would think because of that, Alabama has the lowest premiums for employers for workers' compensation
You would
insurance.
think.
You would think, but we don't. We're right in the middle.
Really?
And we have the lowest
Payout, essentially.
Yeah,
Wow.
we're in the bottom 5 for payouts to claimants for injured workers in the entire country. And so it's problematic.
We've got callers waiting. Mickey is on the line with a question from Athens. Hi, Mickey. Thanks for calling. What's your question tonight?
Well, I'm a truck driver, and I was injured on the job, had a drunk driver hit me.
Okay.
All right, and what the lawyer is telling me is that Alabama has a law, you know, workman's comp picked it up on me, but he's saying that out of my settlement, I had to pay workman's comp back.
Okay. Talk about that.
So we're going to assume, based off what you just told us, that the other truck driver was not your co-employee, okay? Because if he was, your sole and exclusive remedy would be workers' compensation. But if it was a truck driver from another company, then you actually have 2 cases. And you have a workers' compensation case that's going to cover medical bills and things of that nature. It is not going to pay you anything for pain and suffering or mental anguish, because those are excluded under workers' comp laws in Alabama. So you also have a third-party case against the truck driver that hit you, right? And that would just be like a standard car accident. Now, what happens is your workers' comp case has a right of reimbursement, and this is statutory. It's built into that law. The legislature wrote that in, that look, if workers' comp's paid out on your behalf and you get a settlement from a third party, then you have to reimburse workers' compensation what they paid out of the proceeds from the third party case.
Okay.
Okay? And so it's similar to what we call subrogation, which is the fancy legal word for I want my money back. But if you had a case where Blue Cross had paid out your medical bills, they would also be standing there with their hand out to be reimbursed what they had paid out on your behalf. And that's a contractual claim because you have a contract of insurance with them, and it's written in there that you've got to pay them back. It's not a contractual claim with workers' comp. It's statutory. It's written into the law in Montgomery that you have to reimburse out of the third party to workers' comp. Now, sometimes you can use that to your advantage, you know, but you need typically a lawyer to help you negotiate those 2 particular cases, because they do interact with each other.
But you would expect the third-party case, because they've done something wrong, that the recovery would be way more, right? Because workers' comp is going to be a very small amount, and hopefully he's going to get so much more that there's going to be a reason to pursue it.
Yeah, so to give you an example, right? Under Alabama's workers' compensation laws, let's just pick a pretty common injury, a torn rotator cuff with a surgical repair.
Okay.
That's typically going to bring a 3 to 5% impairment to the body as a whole. So that's a permanent impairment. Your body's not the same anymore.
Right.
It's been affected 3 to 5% by this injury, even though you've had a surgical repair. Okay? So under Alabama's workers' compensation laws, that's going to entitle you somewhere between $7,500 and $12,500. In the third-party case, it would have a value probably somewhere between $50,000 and $75,000.
Okay.
Okay, so
big difference.
It's a vast difference what we pay injured workers in Alabama versus, you know, what they would get paid if they were just in a car accident or injured in some other way.
Okay. We got in this email question. This came in from Steve. Steve wrote in, if someone hurts their foot at work and management refuses to give them any assistance after being told of this matter and fails to turn in the accident report, can you sue the employer? Is it better for the person to submit the information directly to the State Workers' Compensation Board or consult a lawyer first? Okay, so take that first part. If your employer is not willing to turn in a report on it, that's a bad sign.
Yeah, and we see this sometimes, you know, with some of these big manufacturing outfits.
Yeah.
They've got little nurses stations set up to try and stave off those workers' compensation claims, right? And they can bandage you up at the little station. They don't have to file a claim. But you do see this sometimes. It happens. I would tell you, look, call a lawyer first, because here's the reason. You know, any lawyer that's handling workers' compensation claims, they're going to work on a contingency fee. And that generally means, look, they're willing to talk to you over the phone and just help you figure out your case, whether you need a lawyer or not. Like Sharon said earlier, no one's getting rich off these cases, the lawyer or the hurt person. And so, you know, generally speaking, we're happy to talk to you and just give you some advice and tell you what to do. But you can go directly to the Alabama Workers' Compensation Board, and that's actually through the Department of Labor, the Workers' Compensation Division. You can reach out directly to them, and they'll tell you the name of the, you know, insurance company that the workers' comp should be provided through. And in addition to that, they'll, you know, walk you through the steps that need to happen, and they'll reach out directly to your employer and fine them if they find them not complying with the law.
So which companies are supposed to carry workers' comp insurance? It's expensive, so if they can get out of it, they don't want to carry it, right?
Yeah, so in Alabama, it's pretty simple. It's just any company employing more than 5 individuals. And so what we do see sometimes is sometimes companies want to call people independent contractors that aren't actually independent contractors to try to keep under that threshold.
Okay.
But yeah, in Alabama, if they've got more than 5 employees, they're going to need to be providing workers' compensation insurance.
Okay. They're telling us take a break. We're going to take a break. We'll be back talking about what you need to do if you get hurt on the job to be sure that you have qualified yourself to get the benefits you're entitled to. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Doviet, with the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Back to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about workers' compensation. We've got William Meservey here from Timberlake and League, and they are personal injury attorneys. So that's everything from workers' comp to car accidents, medical malpractice, things like that. If you've got a question about workers' comp, being hurt on the job and how to get the workers' comp benefits that you're entitled to, call in 536-0077. We've got a caller waiting. We've got Chris on the line with a question from Huntsville. Thanks for calling, Chris. What's your question tonight? Chris, are you with us? What's your question tonight?
Yep, can you hear me?
There you are. Yes, what's your question tonight?
I was wondering if I got into an accident while I was just running errands for the company, would workers' comp cover me? And I'm also wondering if does it matter if I'd be driving a company vehicle?
Okay. If you're driving your personal car, does that make a difference?
If you're in the line and scope of your duties as an employee, then you should be covered by workers' compensation. Now, sometimes where they try to skirt around that is going to be when they start looking at your GPS data. And you see this for commercial drivers, right? And they say, well, you started at point A, and you're supposed to go to point B down the road, but you went up to point C and ran by your house, got you a little sandwich, and then you drove by the bank and pulled out some money for the weekend, and then that's where the accident happened. And so you can get outside the realm of workers' compensation that way if you've taken some wonky route that you weren't supposed to take because you've been running some little personal errands along the way. But by and large, if you're on the job, clocked in, so to speak, and you're in the line and scope of your duties as an employee, then yeah, they're going to owe you workers' compensation for that. injury. And like our earlier caller, you might also have a third-party claim if the wreck wasn't your fault.
Okay, good. We wanted to talk a little bit about notice. So
Yeah.
if something happens to you, is there a window of time that you've got to notify people, and what are you supposed to do?
There is. So in Alabama, we have what's called, first of all, a statute of limitations, which is going to occur in any injury case. You essentially have 2 years from the date that it happened in which to either resolve your claim or file a lawsuit. Now, there's a special requirement built into that statutory codified law down in Montgomery that says you have 5 days to give notice to your employer that you've been injured.
Okay.
If you don't give notice within those 5 days, you'll be barred from making a workers' compensation claim on down the road.
What do you consider notice? Is like just telling them good enough?
Well, the law says that you're supposed to provide it in writing.
Okay.
The courts have upheld that oral notice or a telephone call is sufficient as well. Now, you can also have something called constructive notice, right? So if something falls on your head while you're in the workplace and it knocks you unconscious, and an ambulance shows up and half the company is lined up watching because they're trying to figure out what's going on,
Yeah.
they're going to have a
They
hard
know.
time saying they didn't have notice
They know.
that you were injured on the job. And so you can also prove it through constructive notice. And then there are some injuries that the notice requirement doesn't exactly work for. So
Okay.
carpal tunnel, for example.
Oh, yeah, because that
If
builds
you're
up over time.
a typist, right?
Yeah.
Some respiratory conditions could be slow developing. So if you have a slow developing chronic injury, and now those are harder to prove,
Okay.
of course, but if you have a claim like that, then you might not have the same notice requirement. But you would have a requirement to give notice to your company as soon as you realize, hey, this might be related to my employment.
Okay. And what if they don't do anything about it? If your employer is not helping you the way that you feel they're supposed to, what do you do?
The easiest thing to do is, again, call a lawyer that handles these types of claims. Because a lot of times people say, hey, look, they're jerking my chain around.
Yeah.
And a lot of times they are, because they can. The law allows them to,
Okay.
right? And so it's not always a situation that a lawyer can say, hey, look, yeah, no, they shouldn't do that. Should and can are two different things sometimes, right? But a lawyer will typically walk you through it and say, hey, look, this does sound like they're not doing something they're supposed to do. They should have started paying you that temporary total disability a few weeks ago, and they're leaving you high and dry. So there are times where, you call a lawyer and there are things that we can do. Another thing that happens sometimes is people call the lawyer a year and a half down the road.
Oh.
And it can be hard to untangle the mess that far down the road. And a lot of times, especially in workers' comp, because there are codified things into law, if you talk to a lawyer early on, we can help stave off some of those pitfalls that folks tend to fall in.
Does your employer have to keep your job open for you until you get well?
They're supposed to. The law does provide something called retaliatory discharge. And it says, look, if you've been terminated for having filed or maintained a workers' compensation action, then you have a separate cause of action against your employer outside of workers' comp, right? Now, that can be a very useful tool for some folks, but for a lot of people, it can be extremely difficult to prove because your employer can essentially say, hey, you know what? We don't like people with red ribbons in their hair, and you've got red ribbons in your hair, and we're going to let you go.
Yeah, that's Alabama for you.
That's okay.
Yeah.
They're allowed to terminate you for that reason.
Okay.
Right? So a lot of times what we see is that the reason is pretextual. It is essentially, look, they've come up with, you were a minute late from lunch, and we're going to let you go.
Yeah, it
and
just
then-
happens to coincide with your injury, too.
And then the law says, hey, the burden of proof's on the injured party to prove that their employer terminated them because of the workers' compensation claim and not because they were a minute late from lunch.
Okay. We got another email question. This one is from Ramona. Ramona wrote in, I started my current job about 2 years ago. My back pain started about 6 months later, and I've been seeing a chiropractor ever since. I believe my desk and chair are the problem. Is that something that could be a workers' compensation case?
It can, but you're going to need a physician to link that up, and he's going to have to say that, look, this is from, failure of your employer to provide an orthopedic chair versus just degenerative changes that happen with time and gravity.
Okay.
over the course of your life.
To all of us.
Right? And so chronic back injuries can be extremely difficult to prove on the job unless you have a job that requires lifting. So,
Okay.
for example, for a delivery driver
Yeah.
who's out there, lifting packages from floor to waist
Yeah.
that weigh 20, 30, 40, 50 pounds,
Yeah.
a doctor is going to be much more likely to link up a chronic back problem to that sort of repetitive heavy lifting than they're going to be to someone who sits in a chair all day. But what we do see is that in these repetitive motion injuries or carpal tunnel, they've been a lot more likely to link those up to someone who's, typed at a keyboard for 30 years or something like that.
What is court like? Do you wind up going through a trial at the end of all this to settle things out? Do you have a judge? Do you have a jury? How do you do that?
So sometimes that does happen. If the parties can't agree on a number and they both feel strongly that they're in the right and that the other side is just far off the mark, then you can go and put this in front of a judge, but you can't get a jury, okay? The Alabama Workers' Compensation Act provides that you're entitled to a bench trial only, and that simply means that a judge would be the trier of fact and the trier of law versus just being the trier of law and having a jury be the trier of fact.
Gotcha.
And so you're just entitled to a bench trial. Now, if you do have one of those retaliatory discharge claims,
Yeah.
That
They
entitled-
fired you and they shouldn't have.
that entitles you to a jury.
Okay.
Okay,
And I
so-
bet juries don't like to see that coming through.
so
I bet
you-
they punish.
You can bifurcate or separate that out from
Okay.
the workers' compensation claim and try that separately. There have been some big licks brought back from juries in Alabama
Good.
for those sort of wrongful firings from employers.
Okay. We're going to take a break. Be right back answering more of your questions about workers' comp. Stay with us. If we don't get your question answered tonight, here's how to reach William Meservey with Timberlake and League. They are personal injury attorneys, so everything from medical malpractice, nursing home negligence, product liability, and workers' comp. 256-536-0770 or 800-804-2502. The website law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon Doviet is a family law attorney. She practices everything from divorce to child custody and all things family law. She's located here in Huntsville. Her number is 256-539-7337 and SharonFamilyLaw.com.
Thank you, sir. What if you're goofing off on the job and you kind of cause your own injury? Does workers' comp
That's a
still
good
cover
question. Yeah, so they can get out of workers' comp or parts of workers' comp
Okay.
for safety rule violations, right?
Okay.
And so one of the things we see a lot is people not wearing a seatbelt.
Really?
Not wearing a seatbelt. And so it can cost you. Forklifts, people not putting the strap or
Okay.
things like that. But these things do happen. So if they get you on a safety rule and they can prove that your injury was from you violating a safety rule, not wearing a hard hat or something like that, then, they're not going to owe you the same thing that they would otherwise.
So follow the rules. Thanks for all your calls and questions. We'll see you next week.